So for now, we are now doing panel discussion number 4, which is in relation to arbitration versus litigation, the risk, compliance and enforcement. The moderator will be Dr. Azil Zimo, independent arbitrator and mediator, with a panelist, Alexei, Deputy CLO from Cyprus, Daniel Chia, Managing Director from Singapore, and Dr. Mohamed Soud Alanais from Head Commercial Section at the University of Bahrain. Please welcome on the guests.
Right, good afternoon, everyone. I know this is like the graveyard panel after lunch. We're going to try to keep you awake, we promise. No falling asleep. It's kind of embarrassing for us. We unfortunately have lost both Dr. Mohammed and Mr. Jawad. Both of them had, I don't know, more important commitments maybe? I don't know. But we're here. My panelists, somebody came from Cyprus and somebody came from Singapore. Bahrain is my home. I'm very proud to live here for the last 13 years. I'm going to ask my panelists to introduce themselves first, and then I'll introduce myself, and then we get deep dive into arbitration and litigation, which I promise you the panelists are extreme experts in, and you're going to enjoy it. I know there are some of you with lots and lots of questions, so we will leave some time for that at the end. But we say something that is profound, and you feel the intense need to interrupt us, please do. We're happy to take questions from the floor.
Thank you, Asil. Great to be here. Robishev. I am Deputy Chief Legal Officer at SumSub, where I am in charge of our portfolio of disputes, our intellectual property, and our employment law work. We operate globally, but myself, I am based in Cyprus.
Thank you. That's yours.
Hi. Hello. Hello? Okay. Hi, I'm Daniel. I'm actually a litigation court lawyer, mainly based in Singapore. Actually, I am based in Singapore. I do, I appear actually in the Singapore courts, in particular in the last year and a half, mainly in the Singapore International Commercial Court. So those of you all that were here earlier this morning and had that, and you were privy to that very interesting exchange between myself and the first panel, that's the reason why. Very, very happy to be here. Thank you very much for inviting me, the organizers. Met some great friends, Asil and Alexei already. And I hope that we can have a very interesting discussion.
Absolutely. Thank you very much. Is there a chance we can get another mic that works? Please?
Maybe you are just loud.
Shall we? Are we loud? I'm certainly loud. Anybody that knows me in this room knows I'm extremely loud.
We're all capable of being loud and clear.
Are we loud and clear? Do we need mics? Are everybody happy for us to proceed without mics? With mics, we prefer.
Hello.
That. Okay, fine. Right. So let's start with the obvious question. So the panel today is going to focus on when you look at dispute resolution option between litigation and arbitration for cross-border disputes in particular. What would be your choice, and why will you make those choices? What are the risks relating to those choices, and what are the challenges that we face? I think it's a very interesting discussion to be had among practitioners for many reasons, including the fact that arbitration are not necessarily serving its purpose as much as it used to. There are still many, many delays and challenges to arbitration. So I think the issue of litigation being as a possible solution as a dispute resolution process has now become more and more current, and something I think all practitioners are advising clients need to consider. So today's panel, we're going to try to put both litigation and arbitration under the microscope and come up with some of our recommendations. So I'd like to start by asking the panel, when do you believe arbitration truly shines over litigation and vice versa?
Thanks, Asil. I think, going back to its roots, Arbitration was always called alternative dispute resolution because the idea was that you kind of put technical experts to deal with technical matters, and we can come to a decision which is good, valid, binding, better than a lot of local court decisions because you had that level of technical expertise. Over time, with globalization, you actually also then see that the additional benefits to arbitration was the fact that you had this entire architecture of reciprocal enforcements because of the New York Convention. And now the default rule appears to be that if you have an international commercial dispute, the way to go about adjudicating any dispute that happens in that arena is arbitration because of the reciprocal enforcement. And yes, there are other things about arbitration that people tout. They say it's speedy, they say it can be cheaper, they say it's confidential. But really, for a lot of cross-border multinational companies, institutional investors, various other states, the real benefit and the real attractiveness of arbitration is the enforceability. And that is the default they go to. In contrast, in the past, litigation was always seen as the domain of the national courts, right? Which could then also bring in other non-contractual, non-commercial issues and concerns into a dispute between the parties. Issues of public policy, issues of local law, issues of whether it serves the national interest, and of course, the capriciousness of any kind of local adjudication. And it was in that manner that, parties decided, okay, you know what, if it's purely local in nature, let's do it in the national courts. Depending on which jurisdiction you're in, it can be very fast, it can be take very long, it can be cheap, it may not be cheap. And that was part of the risk of the entire equation. What has happened now is, I think, as again, for those of you all that heard me, both the market, governments and judiciaries, as well as legal practitioners in the arbitration space, see that there is a gap. Arbitration has become more expensive. It has become increasingly long, and there is a sector of clients that are just not happy with that process. And what is interesting is you see then litigation and the courts evolving to try to meet that kind of need. I think it's first evolved in the situation of, say, offshore courts like the DIFC, which implemented things like, okay, you know what, we're going to create an offshore court within a kind of free zone, tax haven jurisdiction, and it will be English law, right? And that has evolved over time if you look at, say, the SICC, where in Singapore, the idea is it's onshore, it's an onshore court, it's not an offshore court. Parties can choose whatever law they want, they can choose whatever procedure they want, they can't choose the judges, but the judges come not from the national judiciary, but from a panel of international experts which come from various kinds of legal traditions. And all of a sudden, that idea has elevated litigation as we know it out of the national realm. Concerns about capriciousness of local judges and local decisions disappear slightly. Issues of public policy also disappear slightly. And in that way, a new international commercial court system has the ability and the potential, and I only say the potential because it's still in its infancy, to bridge the gaps and the weaknesses between arbitration and traditional litigation. And it's a very interesting prospect as a whole. So right now, I would say that at least if you're talking about contested adjudication of some form, let's put aside mediation and negotiation, right? Most parties and clients have three options. They can decide, do we want to go through arbitration, right, which had a particular historic purpose which served arbitration and arbitration clients very, very well? Do you want to go through the national courts, or do you want to then try out this new emerging idea called an international commercial court? And I think those are the three options that are there now. I don't think one is necessarily better than the other. I think it depends, but there are three very unique options, and I'm sure that we can discuss this a bit more in this particular context.
What's in your opinion?
Right. Well, although I'm not in private practice, I am in-house, I have to agree with just about everything Daniel is saying. One qualifier, I will say that commercial courts, international commercial courts such as the Singapore Commercial Court, such as the new BICC, in my mind, they are lumped together with litigation, so they fall under litigation. So in my brain, it's not three options, it's two options, litigation, arbitration, and then litigation breaks down into the conventional litigation and into this new and fancy and not very tested, especially in Bahrain, commercial courts. So generally, and particularly in cross-border context, not the same in domestic, but cross-border situations, I almost universally opt for arbitration. And most of the time, as Daniel said, it doesn't go further, the thought process does not go further than the fact that the New York Convention is a thing that exists and is a thing that is transposed in some way or form into the national civil procedures of just about everywhere. Which means that the awards can generally be enforced, obviously, with a lot of ifs, with a lot of caveats, but generally, you still have a better shot at enforcing a foreign arbitral award in a place, any place, especially if you don't know where you are enforcing it, than you are with a national court judgment, wherever that court judgment could be coming from. So, in my mind, definitely mid-dollar and above cross-border anything, I will almost universally default to arbitration unless I know for a fact that cross-border enforceability of judgments is not a problem in a particular scenario. Litigation, I am not... So the reason why litigation, I see it as domestic, is not that I'm concerned about capriciousness. There are plenty of jurisdictions where the local judicial core is perfectly trained and perfectly capable of resolving disputes that are international in the sense of they are of international nature, which can handle it just fine. Nor is it about the length, because if you apply a concerted effort, you can actually manipulate the arbitral process in a way to make it faster and more efficient, but that does take a lot of effort on the part of everybody who is involved, including the tribunal, including institutions where we're doing institutional arbitration, including counsel, and the parties themselves, to the extent that they actually are sometimes able and sometimes competent to control the proceedings, depending on the skill set that just the staff of the client has.
Thank you. Well, thank you very much for that. But just ending with enforcement and the point Alexei made about if you know where you're going to enforce. We obviously sitting in Bahrain, which is part of the GCC, and judgments out of Bahraini courts are enforceable in the rest of the GCC in line with the GCC Convention and the rest of the Arab world in line of the Riyadh Convention. So in some sense, usually there is always a fear in certain regions in the world that arbitral awards will not be so forthcoming in enforcement. Judgments using those two conventions usually can be very helpful. I'd like to spend maybe just a minute giving you, as you are all here in Bahrain, just to give you a little bit of description of the Bahrain litigation ecosystem, because I think Bahrain has got something quite unique compared to other places. So in Bahrain, you are able to litigate commercially in both Arabic and in English. So if your dispute is above around 1.3 US dollars, 1.3 million US dollars, sorry, then you can litigate your case. You do litigate your case in English if your contract is written in English, which is quite a unique proposition because that doesn't necessarily happen anywhere else. I do know that there's a French commercial court and a German commercial court that has something quite similar, which obviously their national language is not English. However, in Bahrain, from the moment of submission of claim until judgment, including appeal to the Court of Cassation, which is the Supreme Court of Bahrain, all the process is done in English. And that is quite unique. So really, parties, at least in Bahrain, and cross-border between the region, have got a real choice to possibly go to arbitration, to litigation in the courts, in the state courts, that is. And one of the really fascinating things about the judges that sit on those courts, they are renowned arbitrators from both the region and internationally, which is also a very unique feature of the Bahraini kind of state litigation system. And that is reserved for commercial cases, for what we consider to be reasonably high value cases. There have been a number of cases that have already been issued by the Court of Cassation in English in relating to those matters. And that's, I think, is a really fundamental difference of Bahrain when it comes to litigation. Obviously, arbitration in Bahrain is like everywhere. Bahraini courts are considered to be very arbitration friendly. We have two arbitration centers, the GCC Center of Arbitration and the Bahrain Chamber of Dispute Resolution, and both of those have been around for quite a while. I think, taking Daniel's point about the Singapore International Commercial Court, Bahrain is obviously embarking on its own international court, and I know that you guys have heard a little bit about the Bahrain International Commercial Court. I think there are two particular features also unique in the Bahrain International Commercial Court compared to the region, is either it's not offshore. You choose that court, and it will be a court relating to arbitration-related matters. But I think the really interesting feature, which is very different from anywhere else, is the fact that you can choose to appeal cases to the Singapore International Commercial Court. So you come, for instance, first instance to Bahrain, and if you so choose to, you can go to Singapore for your appeal. I think the advantage of the BICC, in my opinion, and I think we'll discuss this a little bit more, is back to enforcement. It's a Bahraini judgment, which means if you are dealing with a regional player, then your ability to enforce that judgment is a lot faster and very quick because of the conventions relating to that. So I just thought it would be interesting as we sit in Bahrain in a kind of unique jurisdiction when it comes to this litigation landscape, both on a state level as well as an international commercial level. We would point that out because that would aid our discussions, because we'd really like to hear your views about what would you choose for your cross-border disputes. Moving on to my next question, we know that confidentiality is a very important feature of arbitration, and the fact that confidentiality does not necessarily exist in court litigation by the nature of the beast, and the necessity for fundamentally courts being open and available to the public. And it'll be interesting, the international courts are also have got confidentiality provisions. So my question is, how do confidentiality play a role with emerging corporate transparency and ECG reporting standards? Please, Alexei.
Yes, I guess I'll start. Well, first, importantly, confidentiality is not secrecy. I don't think it's working.
I'll give you this.
Right, so importantly, confidentiality and secrecy are not the same. Secrecy is at most a tool and not an absolutely used tool to ensure the regime of confidentiality. Also, in most institutional rules and in most jurisdictions, parties don't actually owe obligations of confidentiality. That is with the tribunal, that is with the institution, not with the parties. So if a party needs to disclose the existence of a material dispute, well, in its management report, or if it's a public company, if it just needs to publish this information in their annual report, well, then they do so. They don't have the option not to. So I don't really think it's that much of a problem. Litigation, it's in many we say litigation is public. It is public as a legal matter. It is a matter of public domain, and there are jurisdictions, there are places, of course. We all know English judgments. We have all read a lot of Singapore judgments that are public, but in many places, the most of the body of judicial decisions, most of the body of litigation, it's going to be a matter of public domain, as in legally it's going to be accessible, but it's not going to be practically accessible most of the time in most of the jurisdictions. It's not easily Googleable. Half my cases at some time, you're never going to Google them, even though they are in court and as a matter of law, they are in public domain. But you'll never find out about them. The same applies to arbitration, and for that reason, I don't really think that reporting requirements and transparency requirements, statutory or best practices, I don't think they clash with arbitration or even interact really with arbitration at all.
Do you agree, Daniel? I hope not.
I take a slightly different view, but not because I disagree with what Alexei has said. I think where I come from is that this idea that the main distinction between arbitration and litigation is confidentiality. I think that's outdated, right? And this goes to what Alexis says, that confidentiality is not secrecy. Increasingly, I see courts in various jurisdictions totally accepting the idea that a particular dispute could be confidential, subject to mandatory provisions that require disclosure. For example, on the financials, if you're a listed company, maybe you have to make an announcement for it wherever you are listed, etc. And as a result, the concept that began with open justice, you should know every single facet of a case that comes before the court, has been eroded. And I don't think this is just for the common law jurisdictions. I also see that in the civil law jurisdictions as well. A recognition that in certain instances, whether for trade secrets, whether because, for example, increasingly you have GDPR concerns, you have other kinds of confidential concerns. In China, you have maybe state secret concerns. There is a need not to grant widespread open access to a case file. Now, with that recognition, then comes how the courts historically have done it. And it used to be a very laborious process, which was probably why at one point in time courts didn't like to grant sealing orders and confidentiality orders, which is they have to redact, because especially in the common law world, the idea of cases as precedent is important. You must publish the key aspects of the case in order so that it can be relied upon in the future, right? And you can imagine back in the day before computers, redaction being manual was a pain. With computers after that, it continues to be a pain. But these days, and I have actually tried this, you can use generative AI to redact and replace judgments so easily, okay? And all of a sudden, if you have anonymity as to who the parties are, what potentially the industry is, potentially even which jurisdictions they operate at, the whole need for confidentiality, for public access to justice, those concerns to override confidentiality. I think the balance tips more to, we should try to keep things confidential because it does not hurt public confidence in the judicial process. Okay? So what does this mean? It means, at least for me, when it comes to users of dispute resolution processes, I don't actually advise my clients that there is a significant difference anymore between arbitration and court, all right? In particular, at least in the commercial courts that I see, including in the DIFC in some instances, right, there is almost a implicit understanding that the proceedings are confidential unless there's a need to publicize it. And that shows, again, a growing evolution of the court's appreciation that in the modern world, not everything needs to be public. So slightly different take, but overall, I think I agree with Alexei. I think the main point for me is there is no need to choose one over the other when it comes to keeping confidentiality anymore.
Please, yes.
Yes, so not disagreeing with anything that you said. I am firmly confident that we are on the same page here, but as you were responding to me, I realized one thing. You and I were just talking exclusively about commercial context. There are more types of arbitration, more types of litigation, because we are both commercial coded, because that's what we do. None of this applies one-to-one, maybe partially in consumer and in employment arbitration, yeah. Criminal law, well, you're not going to arbitrate a criminal case, yeah.
I think
criminal litigation, yes. Criminal litigation is its whole other story, because that's where in-camera proceedings, closed proceedings are extremely common for reasons that I believe do not require much explanation. But in North America, especially because that's really where that's a thing, you've got employment arbitration, you've got consumer arbitration. The dynamic there is different. I wouldn't say it's wildly different, at least not in consumer arbitration, employment to an extent. But basically, I want to emphasize that what we talked about right now, it applies in commercial arbitration, because this is what really, realistically, we're here to talk about. But there are other layers to this, other aspects. Again, mostly in the US and Canada, but still they do exist. They are a thing.
They do exist. Absolutely, and they're huge. Okay, so that's really interesting. So if any of us ever Google what are the advantages of arbitration over litigation, one of the first and number one always comes up as confidentiality. And you've heard it from the experts that confidentiality is, in many places, is no longer a distinguishable factor between the two. Now, I want to turn to the experts on their own specific jurisdiction and sector. So Alexi is in fintech and digital world. I would like to ask you, from all the things you said, with regards to arbitration versus litigation, as well as confidentiality and enforcement, is there any special features that we need to bear in mind when we're thinking about the fintech industry or digital world?
Yes, so they're not, yes, but they're not particular to the industries, they're particular to the modality of business that we and the overwhelming majority of the sector operate, which is business-to-business software as a service. What follows from that is that you are a software vendor who sells their services, usually at mid-dollar prices in terms of overall volumes, to hundreds, thousands of customers all at once. It follows that apart from the largest of transactions, you will be dealing with dozens, hundreds of contracts with customers, with your clients from across the globe. You're global in that sense, which means that you can't really, theoretically you can, but realistically, as a practical matter, you're not going to be researching and figuring out whether you are willing to litigate with them either in a court or in their own court or in a different court, and then figure out what to do with a judgment from that jurisdiction if it ever comes to that, which is why another point in favor of arbitration here, because it's kind of standardized. It's not the same everywhere, but it kind of follows the same general refrain in most places, not everywhere, but in most places, which is why we typically tend to arbitrate in a B2B situation. When it comes to B2C, it's different because consumer law overrides everything. Just arbitration is not a thing, again, outside of North America. It's always going to be litigation, not because you have a choice in the matter, but because this is how it is. This is what the law says locally. Can
you comment about, in the context of what you just described and the fact that your customers are global and you have arbitration, so this is why you believe the New York Convention is what really makes a huge difference?
Yes, as well. So this is the primary thing. This is really where the analysis stops in practice. If you think about it further, if you go past that, there are more things that are in favor. It's just that even if they weren't, like the New York Convention still would have made me make that call. It's the fact that I can control the proceedings in a language that I can understand in English, regardless of the amount of claim. And it's the fact that in most seats, and this is something I have to apply some conscious effort to, but in most seats, I am not restricted in my choice of representation. I don't want to have to be locked into local counsel, or sometimes even into counsel in the sense of licensed lawyers. I personally come originally from a jurisdiction where the overwhelming majority of the legal profession are not, in fact, licensed lawyers, but they do have access to court, and they do have right to representation. So I really don't like this cliquey, sometimes restrictiveness. So I try to keep my arbitrations out of the seats that do this protections thing. It's not good practice.
Very interesting. Singapore has got a history with the legal profession being cliquey, which they've left behind them. So can you tell us about, what do you think about what Alexi said about the legal profession restrictions in litigation in particular, and the fact that certain seats allow for your absolute choice of legal representation regardless of the license? This is my first part of my question. The second part of my question, can you not only answer the question in regards to Singapore, but with a little bit of a flavor of the rest of Asia? And I know Asia is huge, but just a little bit of a flavor, please.
In case I forget what the second question was, you should remind me later. I don't think it's a situation where Singapore or any different kinds of, or other jurisdictions are cliquish in the sense that, they're very protectionist. I think, again, if we go back to history as to how legal systems were first created, there was a need to license those professionals that were going to court for you, and that is something that has just stayed on. Now, some jurisdictions are more progressive of it right now, some are less. But I think to Alex's point, which is a very, very valid one, from the client's perspective or the multinational perspective, if you have standard terms and you contract with B2B or B2C companies and consumers all over the world, you do not want to hire lawyers in every single jurisdiction to fight cases, right? And therefore, one of the primary concerns in that scenario is going to be, I want to have the same lawyers that can appear in whatever dispute that comes by, because it's going to be this particular seat that we have chosen. I know the rules very well. I can get economies of scale from the law firm, and the lawyers are very familiar with my business, right? So from that perspective, I totally understand. But the other perspective, which in a way, if we want to be a bit more ambitious, we're not just looking at clients and multinationals as the only users of the court, right? The other big stakeholder users of the court are legal professionals like us, right? As well as, the judiciary, etc., and all that. And from our perspective, do we really want a situation where we are only limited in practicing? And I'll come back to how arbitration fits into this. Do we want a situation where we are only limited in practicing in, number one, the jurisdiction that we are familiar with, okay, the jurisdiction in which we are licensed, and number two, or do I want a situation where I go out and I compete in a way with the rest of the world, where if you go into arbitration, as most of us who have done arbitration are aware, it's huge, the amount of legal professionals that claim to be international arbitration specialists, and you can't stand out. So why am I saying this? Because there is also another way where, bit by bit, there is an opportunity for legal professionals actually to up their game and compete in an international forum, right? And it takes time. And I'm speaking just as a Singapore lawyer, where 10 years ago we didn't have the International Commercial Court, right? And yes, there was a lot of arbitration that was happening. But one thing great that the International Commercial Court has done for Singapore lawyers, it is that because you have these international disputes that come into the International Commercial Court, you have these world-class judges that were empaneled on it. And you then have international lawyers that come in, register, to be able to appear before the International Commercial Court. You have the opportunity to co-counsel them, go up against them, compete with them, and all of a sudden, you see best practices come in. In fact, for the SICC, in a lot of cases where there is no confidentiality concerns, no sealing, you can go in and watch. It comes to your doorstep. And, for a lot of us, at the time when we were still experimenting with this model, what we did not appreciate was how it helped to upskill our lawyers very, very quickly into international practice, those particular considerations. And I'm not just talking about the lawyers in the big law firms, right? The smaller law firms as well, who came because they wanted to see how something like this worked at an international, which you would not get to see in arbitration because of all the confidentiality concerns. So, again, I know I always do this. I see it changing slightly. I see the situation where you have the traditional, protectionist concerns, and then of course you have the arbitration where, don't worry, total freedom of representation, which of course is what the clients always want, the fee-paying clients want. But with at least the International Commercial Courts, and probably even with the DIFC to some extent, you also see another stakeholder that is being ignored, actually upskilling, training, and getting a better chance to compete at that international stage. And that is what I find interesting. Okay, sorry. So that's the first question. I can't remember what the second question was.
The second question was about Asia. You can give us a bit of flavor about Asia? Understanding there's a very big difference.
Right. I think Asia is actually a bit like the Middle East, right? You do have, Asia is not uniform. There are many, many different languages. There's something like 50 or 60 countries in Asia, all from various legal traditions. And therefore, the struggles that Asia has with enforcement, with language, with cultural nuance, those are things which, I'm sure here in the GCC, is something that is very similar. The difference, and I think the big thing that the GCC has over us, is that we do not have in Asia some kind of pan-Asia-wide treaty which allows for enforcement all over the rest of Asia. It'll be great. I think that's something that we're all trying to work towards, but it's easily decades away. What we have is a patchwork of treaties, MOUs, which try to make this work. That being said, and this goes to Alexei's first point about enforcement, what is interesting with Asia and the Middle East is we see that increasingly there is a lot of cross-border money flows, transactions, investments between the Middle East and in Asia. We see it all the time. Chinese companies, Japanese companies, Korean companies are interested in whether it's public sector building works here in the GCC as well as in the Kingdom of Saudi. All right, we see that a lot. And the question then, which I think it's quite apt for us as legal professionals when we think about it, even the corporate professionals that are trying to draft the transaction contracts, is what kind of dispute resolution clause is going to appeal to the Asian stakeholders that are trying to invest into the Middle East. So not just look at it from the Middle East perspective. From the Middle East perspective, sure, everybody maybe know Bahrain, they're happy with Bahrain law, they're happy maybe with Bahrain courts, they may be even happy with arbitration seated in Bahrain. But from an Asian perspective, that is not something which comes naturally to an Asian client. Yes, I mean, after speaking to ASEAN and of course doing my own research, I know there is a very sophisticated legal system here, but that is not well known necessarily in Asia. What is well known in Asia is, again, sadly, Singapore has been doing this for quite some time. We kind of trust the Singapore judges, we kind of trust the Singapore system, even if we don't have direct treaty obligations for registration of judgments. We do have MOUs between the courts which will effectively get you registration as well. So there is a nice compromise here, and maybe this is where the BICC should pitch itself, right? Bahrain law, because the investments are, I'm just giving an example, it can flow both ways, but let's talk about, some of these Asian Chinese contractors coming to invest in Bahrain to build infrastructure. Bahraini law, because of course, everybody here in the GCC is familiar with Bahrain law. Okay? BICC courts, legal professionals can advise on Bahrain law, can go to the BICC at first instance, etc., in order to litigate all of that. And your concession then to the Asian party is, don't worry, we did this in collaboration with Singapore, and at the end of the day, there is a potential right of appeal to what we call an international committee that sits in Singapore that will hear, it's like an appeals board for the BICC. And to your clients, you then, so if you say that, Asian clients are going to go, oh, okay, I'm familiar with Singapore. If they did this in consultation, it must be okay. And for your clients, you say, don't worry, on the appeals board, there will likely be either a Bahraini lawyer or a GCC lawyer or a GCC ex-judge or arbitrator that you are familiar with, because that's just how it works. And that, as a dispute resolution process, becomes potentially attractive to all sides. So that, I guess, was my little pitch for why I think there is a lot of potential in the BICC. And we're not talking about worldwide enforcement or anything, but just from the Asian to Middle Eastern corridor, I can see a lot of potential there.
Thank you very much. Thank you for that great pitch. In my previous life, before an independent arbitrator, I was the advisor to the Bahraini Minister of Justice and the Bahrain Chief Justice, and we worked very hard on the BICC. And I took him out for dinner yesterday, and God, I'm very glad, because he really lent his all the tips on the BICC. But actually, it's exactly the vision of the BICC, is to provide a solution for the region, not for Bahrain. People that do work in Bahrain know that Bahrain is a very small market. We're not big players in the business world, but we're absolutely surrounded by huge economies in the Kingdom of Saudi Arabia and the UAE and the various other GCC countries. And the idea that Bahrain is trying to offer itself as a dispute resolution hub, and with the Singapore connection, is to give real confidence to the people that don't actually know how amazing Bahraini legal system is and how great the courts are in Bahrain, and a lot of people don't know, is that everybody that you speak to say, if the Singaporeans go in bed with you, then you must have something special. because the Singaporean legal system is very well respected. It's probably one of the very few courts in the world that get quoted in the English courts, and therefore it's a court. SICC has proven itself to be of great quality and of great judgments, and able to deal with the needs of the business community. And I think the BICC joining forces with the SICC it will be a great potential for those Asian partners, but also providing solutions for our local, regional players that they don't have to go too far away from home to litigate, or more so arbitrate. And I think it may be to your point, and I know a lot of people that work in the region understand, we have a lot more familiarities, between ourselves that more than probably in Asia. Most of us speak Arabic. Our legal systems, most of us are civil law. They are rooted in the Egyptian Civil Code, so we all kind of copied from the original Egyptian Civil Code, which came from the French Civil Code. Yes, with some nuances, and those nuances are very important, and you must read the original text. But actually, in the region, we have got a lot more similarities than actually differences in legal terms. And I think that's a really positive thing. I think also, the rise of Singapore has shown that there are other non-traditional seats, the London and Paris, etc., that could be a really a trusted seat of arbitration. And I think the region is all fighting. Saudi Arabia is doing it with the SACA and the big push of SACA as a place to do arbitration, as an institution for arbitration. The UAE are trying with Arbitrate AD, with DEAC, etc. So there is a constant push within the region to attract the dispute resolution into the region and not lose it to Paris or London, which is your usual kind of players on the scene. So I'd like to talk a little bit about ethical consideration. And I think one of the most important thing about arbitration, and having possibly licensed lawyers or not licensed lawyers, having lawyers coming from different parts of the world, the ethical requirements, the ethical rules, the ethical code are different. We all know this. Any of us that have been dual qualified anywhere know that the ethical rules can be considerably different between many, many different countries. And that plays a big role inside in how the procedures are conducted, particularly in arbitration. So when you are appearing in international commercial arbitration, what are the ethical rules that you need to bear in mind, bearing in mind that you are not at that moment committed to any particular legal system?
Before I start answering, yes, the fact that it is well known, it's trite at this point, because that's been the case for 100 years and it has never changed. It's that in an international arbitration, unless coincidentally your counsel are from the same jurisdiction, outside of that, they're going to be subject to different ethical rules as in professional ethics. That is a known problem that to date has not been solved. There are, of course, like soft law guideline type documents, but they are soft law guideline type documents, which is, so take them for what they are. And that I think is actually one big point for litigation in many cases, because that I was talking about a single set of rules, a standardized set of rules. Well, this is one place where litigation has that over international arbitration. A single set of rules, meaning that you know that your counsel and the other party's counsel have the same obligations towards their client, each other, and the tribunal. So typically, there are many ways to tackle this. What I try to do is first of all, I try to parrot the Anglo-American style of building professional ethics rules. So privilege as opposed to different professional secrecies. Don't lie and don't argue things that are completely and utterly indefensible, that you know are complete nonsense. Really, once you hit those basics, at least until you have been able to determine together with the tribunal, together with OC, with the opposing counsel, the rules of procedure, if you hit those basics, then you'll be fine most of the time. One big problem is, of course, discovery disclosure, but I think it's debatable whether, or the fact that in many places that is not a thing that exists. But I think that's more so procedural than it is ethical. And it can be solved by carefully drafting, carefully determining, and discussing transparently and at length, if needed, the rules of procedure between the two parties, the two sets of counsel, and the tribunal when and as required.
Thank you. Daniel, is there a special consideration for banking, maybe energy or other sectors?
Maybe before I come to that, I just wanted to respond to what Alexei had said about ethics. I think, in my personal experience, the enforcement of any kind of ethical consideration in the process is really led by the adjudicator, whether it's going to be the arbitrator or the judge. So, insofar as there are ethical failings in the procedure because you have, say, opposing counsel that's just lying off the top of their head, hiding documents, etc., the real police person that can actually pull that out, stop that kind of behavior, has to be the arbitrator, right, in an arbitration. And it's therefore so important to actually make the correct decision about having a strong, good, experienced arbitrator manage these disputes and going to renowned institutions that are going to appoint strong arbitrators to manage that. I mean, because you don't have a situation where the court will just get angry and just scold people. So, I do accept that there are more rigid procedures in court. It is more likely that you can actually have more clarity on what the ethics is, but I don't necessarily think that for arbitration it means there is greater risk. Ultimately, it boils down to the strength of the arbitrator and the importance of the arbitral appointment. Now, when it comes to banking, ESG, and those kind of ethical considerations in those fields, I think if you act for generally a very large international conglomerate, there are always going to be reputational concerns. And a lot of that reputational concern and compliance concern also becomes whether we have hid any documents, whether we have complied with the court order, whether we are being misleading. And, in that sense, I find that for the larger organizations, they tend to be a bit more conservative in their views about positions that they want to take. They want to take positions which are defensible. The GC more often than not, has to go to the board and say that this is the position we are taking because I'm satisfied it is defensible. And in that sense, there is that self-check. Now, where I see less of that tends to be in the smaller players, the local businesses, or even like just the transnational businesses, not really in the multinational businesses. So I wouldn't break it down to banking, energy, ESG. I think, it's going to be more about size and the ability to actually self-check based on their own compliance departments.
Has either of you have got surprising stories of when you enforced awards anywhere in the world and you were like, wow, I didn't expect it to be like this? Or horror stories where you didn't expect your award to be not enforced? While you think about that, countries around the world spend quite a lot of time trying to figure out how to become arbitration friendly, especially the ones that are aspiring to be arbitration seats. Bahrain, Saudi Arabia, UAE, everybody is working very hard on this. And the procedure to enforce awards are something that people look at very, very, very closely. Now, obviously, public policy issue is the fear of every single person that ever wants to enforce an arbitral award, because that's the number one way that arbitral awards have been refused recognition often in certain jurisdiction where the judiciary is skeptical of arbitration. But one of the things that I think the landscape has changed very much in the GCC is more and more arbitral awards are being enforced, more and more application for annulments are being refused. And I think, the judiciary in both Bahrain, in the UAE, as well as UAE, Dubai, and Abu Dhabi, because UAE is obviously a lot bigger than just Abu Dhabi and Dubai, but these are the two judiciaries that are most reporting, as well as Saudi Arabia. They've worked very, very hard to enforce all of the awards that comes to them. And I think that's an edge of two swords, because sometimes you get arbitral awards being enforced even though all of us looking at that arbitral award are quite certain that that award shouldn't have been enforced. And bearing in mind so much cross-border disputes happen in arbitration, in confidentiality behind closed doors, what do you guys think about how do we actually maintain quality of the arbitration process, of the arbitral award, in light of the fact that we don't have an appeal?
I don't think it's always a situation that awards from every seat does not have the ability to appeal, right? So, I mean, in England, there is a process in which you can actually get leave to appeal on particular points of law if it covers under English law. There is a consultation that is going around in Singapore, whether we adopt that as well. And I think it shows the trend that users of these processes are saying I don't think this is a situation where the court said, let's do this because we want to have more work for ourselves, right? It's more of a situation because of public feedback. There is some dissatisfaction with the quality of some of the awards which are coming out of the international arbitration process. And as a result of that, there is at least some courts or some governments feel the need to kind of step in to again fill that gap where we want arbitration to continue, but we have to make the process more robust against maybe certain failings. And that's really where the appeal idea comes from. So I think it's an open thing right now, whether that trend will continue, or whether you are still going to have the situation of, no appeal on points of law, no appeal on errors of law, errors of fact. It's just a registration due process issue. So I think that's one. When it comes to, you would ask stories about enforcement. Let me tell you a good story and what I see potentially are problems down the road. So a good story is, I recently did, I think, one of the fastest enforcements of an arbitration award, at least in the common law world, and that included an attempt to set aside, which was, I think, within 4 months, there was a recognition to enforce. The award was enforced. The setting aside and the challenge and annulment proceedings was dismissed within 4 months. Now, in the common law world, I know probably in civil law it is faster, but in the common law world, that's amazing, right? It takes anything between 8 to 12 months usually to get that. And this was an award for about $700 million US. So it wasn't a small award. And the courts could actually get their act together to do it in 4 months. Singapore International Commercial Court. But the reason why it was so fast was because there was a willingness on the court's part, as well as on claimants' or the claimants' counsel's part, to move that process very, very quickly. So again, to Alexei's point, when the stakeholders wanted to move quickly, that process can be quick. We had a respondent that was not keen to do it, but it basically got overruled by what the court wanted, because the court is not concerned about the fact that you may set aside their decision because they made something unfair. Okay. So that was quite eye-opening. If there was an appeal, that appeal was scheduled to be heard 3 months later. So within 7 to 8 months, you get certainty as to whether the award could be annulled, whether it could be enforced in the jurisdiction of the seat. And I thought that was really quite special. Now, the second part, which I think we do not give enough attention to as we talk about it, is arbitration as a process, international commercial arbitration as a process, and this system of international enforcement because of the New York Convention really grew up at a time when globalization, as well as the interconnectivity of all, not just trade, but governments, the idea that we're going to have pan-government institutions, they were really at the height of their power. And you do see globalization fracturing right now, right? You'll see the emergence of a multipolar world. You see the emergence of spheres of influence. You see the emergence of states acting purely in their own self-interest and sometimes vindictively against who they perceive to be their enemies. Now, where does that leave international commercial arbitration when the entire enforcement regime is predicated on the fact that you have a treaty, you abide by the treaty based on reciprocity? There is a potential that that system gets upended. There is a potential that actually the ease of which we are used to enforcing arbitral awards is going to significantly change. And we see this already in respect of a couple of countries, which I shall not mention, right? But yeah, Alexei can mention it's Russia. I can't. Yeah, and that trend may continue to other countries that are not happy or feel that a particular tribunal is biased against their own national companies. So where does that leave us as professional and clients and users of international commercial arbitration? It means that we have to increasingly recognize the default of saying, let's put an arbitration clause because I'm going to get enforceability and certainty of the enforceability. That goes out the window. Okay? You have to be quite strategic right now in deciding what is your dispute resolution clause going to be. You're going to have to be quite strategic in where you want to enforce, over what kind of assets you want to enforce. And I think it prompts a further conversation with clients, especially on their standard templates. But again, I do see that as a real danger, and therefore it's going to make our lives a bit more complicated, and that's why you need lawyers around.
Thank God you need lawyers, and we're not going to be replaced by AI.
Plainly, dispute resolution clauses and dispute resolution mechanisms, they're not going to fix everything. The fact that the New York Convention is, what, 1950, I forget, 1958, right, so 1958, a very different world. Most of us here were not alive at the time when that was, when that was created. Today, the world falls back, it lapses back into the fragmentation in terms of the general term is politics, so in that sense it falls into fragmentation, but at the same time it's more connected than ever before, and that's not going anywhere. The internet will not be shut down, mostly. And so, mostly, I said mostly. So, but even in China, we go to China and enforce the words sometimes. So this framework, it was built in a very different world. It's adaptable, but only to an extent. At the time, you did not have people earning millions of dollars out of their basement with contracts sitting in the basement in their sweatpants with 2 employees or 2 contractors in one of them sitting, I know, in New York, and the other one sitting in Amsterdam, and the third one sitting in, I know, Seoul, earning millions of dollars and entering into dozens and hundreds of contracts. You did not have that. That was not possible until 15 years ago. So the systems, they can adapt, but they are too clunky to adapt. The New York Convention, it is an anomaly. It is an anomaly as far as these international legal order things go. And I don't think we're getting another anomaly. People who talk about ADR, mediation, people talk about mediation all the time. What am I going to do with the mediative agreement? The Singapore Convention on Mediation. How many states have ratified that? Single digit number of states. And that's been around since 2008, I think, 6. Almost 20 years. The Singapore Convention on Mediation has been around for almost 20 years, single-digit number of ratifications. 5. I think it's up to us as not as a profession, but more so as a market to develop new tools that will start out as private tools as arbitration 150 years ago back when. And we already see that with sort of private not enforcement, but sort of private quasi-enforcement of things, of transactions that are fully entirely managed on certain platforms. We already see that happening occasionally to an extent, and I think this is where, for these types of businesses, for these lines of economy, where that may or may not go. And this is where all of that, all the talk about insert your technology here, this is where that will go. So all the blockchains and the AIs, this is where they will go. They'll not be an overlay, they will not be laid over the existing base mechanisms, which work with flaws, but they don't work universally, absolutely, and everywhere.
Thank you very much. I think we should take some questions, if there are some. If there are none, we've got plenty more to talk about. Yes, please. Over here. There.
Hi again. I'd like to thank the panel for the very interesting conversation. I just have one question to build up on what you started the panel with. So, do you think, due to the challenges that are facing arbitration nowadays, which you talked about, so do you think that now it basically goes down to how you choose the arbitrators, or which seat of arbitration you go to, which law you're applying? Is this like the bottom line today for parties that are choosing arbitration as their dispute resolution method in mostly commercial contracts? Because from personal experience, lately we've been dealing with a lot of clients who wish to just skip the arbitration clause that they wrote in the contract 6-7 years ago before the dispute arose, because basically they're saying that going to the courts, especially in Dubai, for example, is going to be a much more efficient process, and it's going to be much easier than just going to the DIAC and choosing arbitrators, and it's going to be a hassle, and it's going to cost them 10 times, and I'm not joking, 10 times more than what's going to cost them at the national courts. So what is the panel's view on what I just said about this? Yeah, that's it. Thank you.
All right, thank you. First of all, everything that you said, I think is correct. I said earlier that there are private mechanisms, and actually one of the ways both courts and arbitration and really any other mechanism can adapt is by introducing ways to build the entire process faster and more efficiently, just so that instead of going up in complexity and your length, as well, arbitration to a large extent does, and so does litigation often, to be honest, so that it goes down. Courts, especially courts with high international and high dollar workload, they've started that earlier, not all of them, but SICC is an example of that, as far as I'm, in my view. Some other courts do that as well, so catering both to internationalness, but also to sort of like higher efficiency compared to the normal court procedures, where like every jurisdiction complains about their backlogs. There's a reason for that. In arbitration, it's a bit more. Arbitration is decentralized, unlike litigation, because litigation, in every country, it's localized in a jurisdiction, and in that jurisdiction, it is centralized. That is not entirely true of arbitration, but in that there's also an opportunity. There are beginnings. They don't really work yet, but I think they will. We're in the stage of janky, clunky prototypes. There are mechanisms for very fast online ADR, and ADR in this case is actually euphemism for arbitration mostly, that go as follows. Basically, everything is online. Filings, submissions, evidence are very limited in length and volume. All parties have to consent to arbitrate entirely online without going through like the conventional, like 4 stages of submissions plus hearing plus post-hearing something plus costs, which you sometimes get in a conventional arbitration, mid to high dollar arbitration. And they consent that in 3 months you're going to get an award on very quickly, based on a very limited set of submissions, with a very limited opportunity to present your arguments. Yes, you get one shot at it, basically, but in 3 months you will get an award rendered entirely online without a hearing. So, and there we go. So it can exist. It can render an enforceable award, but then it comes to judiciaries to actually recognize it as a valid and enforceable award. And this is where it's going to vary wildly. And this is where we go back to courts, to the level of not necessarily support for arbitration, but support for a particular way to conduct the arbitral process. Because at some point, it's not an unfair process, but it's not due process as in the full opportunity to argue and present cases at length the way we're used to it. That is closer not in procedure, but in spirit, to again what we would usually talk about arbitration as being as 20, 25, 30, 40 years ago, so this faster, more commercial thing. Now, it can circle all the way back to that, but then the courts will have to accept it as these awards get to be attempted to set aside or get to be enforced.
I think the client has buyer's remorse. But putting jokes aside, I think what you are going to see is that there will be a fight over the various seats of arbitration as they start to amend their rules to take into account precisely that particular client's concerns. So 8 years ago, 10 years ago, you did not have things like an expedited procedure to deal with small claims in a lot of the major institutional rules. You now see it in the LCIA, you now see it in the SIAC, you now see it in the Hong Kong IAC. You do not have things like a power for a summary dismissal of the case, akin to just a strikeout because maybe there is no claim that is sustainable. Recently, the SIC has also implemented what is called as power to summary dispose of a case. That means to grant summary judgment in any level, at any amount of a case, up to the arbitrator. So you will see, I think, a lot of the seats and the institutions start to put in these powers and these rules in order to make sure that the clients get what they want. Then the next thing, and this is the harder part, you need to embolden arbitrators to use these tools, and that takes time, right? Again, back in the day when expedited procedure came out, most arbitrators were very scared because they thought, well, expedited procedure means within 6 months you must render an award. That deprived the parties of proper due process and justice, and it can be liable to set aside. So even though there was the power, even though the appointment came from the Court of Arbitration or even the president of the SIC, arbitrators were turning it down because they didn't want to take the risk. So I think, to answer your question about what people should focus on, I think having particular attention, if you're already caught with an arbitration clause and you have to, or your client wants to have arbitration for whatever tactical reasons or strategic reasons, pay attention to the seat and the institutional rules. I think that is very, very important. If you have an ability to somehow nominate a process to get in a strong arbitrator, or if you can look at who is on the panel of those institutions, make sure that the arbitrators are strong, they're experienced, and you probably will have a slightly better outcome, less dissatisfaction with fees and time.
I think my advice is, when it comes to dispute resolution in general, is you need to think about it. This boilerplate stuff, whether it's from the arbitration process mechanism, arbitration mediation or whatever, or court, or whether it is the procedures. I think that one of the very clear message of the panel is you need to think about it. You need to invest a bit of time into choosing what you're going to do. Are you going to go to court? Are you going to go to arbitration? Think about where you're likely to enforce. If you're going to go to arbitration, what seat? Are you going to try an international court? You need to think about these things. We all agree, and I don't know if we're surrounded by dispute lawyers. I mean, often are. I'm hoping there's a lot more dispute lawyers in this room. We dispute lawyers are always looking at our transactional lawyer and say, the midnight clause, the famous one that nobody thought about, and that causes everybody the most amount of headache. I think it's really important that when it comes to making every single decision, you've thought about it well. If you are in an arbitration award, try to make it institutional rather than ad hoc. It just makes life a lot easier, honestly. Think about who your arbitrator is, what the language is, what the applicable law, think about all these things. And think about if there's an alternative. Is the state courts better? Am I enforcing in the region? Maybe go to one of the international courts, the IFC, the ICC, whatever the appropriate one. I think tailored solution to your clients is now a duty with this amount of choice. I think our time is up, except if somebody has any pressing, burning question. Excellent. Thank you very, very much. I hope you enjoyed this. We certainly did. And enjoy the rest of your day. Thanks.
Thank you. Now I request the moderator to honour our panellists with the mementos.
Thank you so much.